my name is Louise Gullifer. I'm chair of the law faculty. It is my very, very welcome task to, well, first of all, to welcome you all here for this wonderful occasion and to introduce our speaker tonight. We're particularly delighted to welcome those who are guests of Campbell, and thank you all for coming. I know people have come from quite a long way to be here, and it's lovely to see you all here. So Campbell joined our faculty in October 2024 as the 1973 chair. And the 1973 chair, as its name suggests, isn't a terribly old chair. It started in 1973, but it has had some very, very distinguished people holding it during its short history. Kurt Lipstein, SFC Milsom, Bill Cornish, Sir Bob Heppel, and John Bell, who very kindly is here tonight. Hello, John, it's lovely to see you. Thank you for coming. And adding to this distinguished line of professors, we now have Campbell McLachlan, who is also a very distinguished addition to that line of 1973 chairs. So I'm going to tell you a little bit about Campbell, and then I'll tell you a little bit about what's going to happen this evening. Campbell was born and had his undergraduate education in New Zealand, but came to the UK in 1985. He gained the diploma cum laude from the Hague Academy of International Law and a PhD from University College London in 1988. And he then joined the firm of, as it was then, Herbert Smith in London. And he was elected to the partnership in 1992, so he must have been a very young partner indeed at the time. Anyway, he became head of its international law practice group. He did extensive research work while he was there for the International Law Association on both international civil and commercial litigation and the practice and procedure of international courts and tribunals. And then in 2003, he returned to New Zealand to a chair in law at Victoria University of Wellington. He was elected president of the Australian and New Zealand Society of International Law, and in 2015 as a member of the Institut de Droit International, and he served as rapporteur of its commission on the equality of the parties in international investment arbitration. Over the years, he's written a number of incredibly significant books: Lis Pendes in International Litigation, Foreign Relations Law, International Investment Arbitration, Substantive Principles, 2 editions, and most recently, and not irrelevant to this lecture, The Principle of Systemic Integration in International Law, which was published by OUP in 2024. He's also been a specialist editor of Dicey and Morris, Conflict of Laws, since the 14th edition in 2006. He's held visiting fellowships all around the world, All Souls Oxford, NYU, Humboldt University in Berlin, and in 2022-3 in Cambridge, where he was the Arthur Goodhart Visiting Professor of Legal Science. And while he was in Cambridge, he taught a course that I think has some relation to his book and perhaps even some relation to what he's going to talk about tonight. In 2024, he gave the general course at the Hague Academy of International Law. As well as his scholarly work, he maintains an involvement in practice of international dispute resolution. He was appointed Queen Counsel in 2007 and is associate member of Essex Court Chambers. He also serves on the Permanent Court of Arbitration in The Hague, on the panel of arbitrators at the International Centre for the Settlement of Investment Disputes at the World Bank, and on the joint proposal of UK and EU on the panel of independent chairs of arbitral tribunal under the UK-EU cooperation agreement, and frequently serves as president of international arbitral tribunals. And he is a fellow of Trinity Hall while he's here. We're very pleased that the Master of Trinity Hall is here to hear his lecture. And the 1973 chair is styled for him while he's here as Professor of International Dispute Resolution. So we're delighted to have Campbell in Cambridge. We're delighted that he's absolutely hit the ground running with teaching a very large course of very enthusiastic students, which appears to be going very, very well on international dispute resolution. But tonight, he's going to give his inaugural lecture on the interface between public and private international law. Now, in the tradition of inaugural lectures, there will be no questions. So he will give the lecture and then no Q&A. But You are all invited to join us for a drink outside, upstairs, if you have any questions, I'm sure you might be able to ask either Campbell or somebody else what the answers are. Thank you very much, Campbell. Over to you.
Thank you, Professor Gulliver. My lords, masters of Trinity Hall, Keys and Downing Colleges, dear friends and colleagues, dear students of international law, ladies and gentlemen. On Friday, the 15th of February, 1788, in Westminster Hall, Edmund Burke rose to begin his opening speech on behalf of the House of Commons before the House of Lords in the impeachment of Warren Hastings, Governor-General of Bengal. It was a scene of extraordinary drama. In addition to 170 members of the House of Lords, judges and lawyers, there were 200 members of the House of Commons. Tickets for the public gallery reportedly changed hands for the equivalent in today's money of £5,000. Queen Charlotte herself attended. Well, Burke's 4-day opening is one of the most celebrated pieces of advocacy in the English language. The impeachment of Hastings was a general attack on the whole corrupt system of governance in India, instituted under the aegis of the East India Company and continued under Hastings as Governor-General of Bengal. At the center of Burke's opening was an analysis of the vice inherent in the conflation embodied in the East India Company of the international exercise of private, corporate, and public sovereign powers. As he relates, by the reign of King Charles II, the company did not seem to be merely a company formed for the extension of British commerce, but in reality a delegation of the whole power and sovereignty of the kingdom sent into the East. In fact, he said, it's a state in disguise of a merchant, a great public office in disguise of a counting house. The consequence, urged Burke, is that there's no people to control, to watch, to balance against the power of office. He said this wasn't to be expected in a corporation. Their lordship shouldn't expect something which has never happened in the history of the world or any corporation, that they should ever be a proper check and control upon themselves. Well, nearly 250 years later, and in an utterly changed world, the central issue that Burke identifies, how to distinguish and to regulate the power of states and of corporations in the international sphere, seems as pressing as ever. I want to suggest to you this evening that consideration of this question lies at the heart of the interface between public and private international law. It is a great honor to have been elected to take up a chair occupied by such a distinguished set of jurists, and in particular honor to have the previous incumbent, John Bell, with us this evening. But I want to, in choosing to take up this theme this evening, I want to pay a particular tribute to the first holder of the 1973 chair, Professor Kurt Lipstein, who commented in his valedictory lecture in 1977 that the relationship between public and private international law had occupied him more than any other problem. But it must be said, however, for the reasons that I shall develop here, I find myself respectfully, but nonetheless profoundly, in disagreement with Lipstein's ultimate conclusion that the two fields have nothing to do with each other, nor do I consider that this has been supported by the evidence from practice in the half-century since he gave that valedictory lecture. My own immersion began very much in the practice of international litigation, first at Herbert Smith, where we acted on behalf of both states and of corporations, very much under the influence of F.A. Mann, whom I knew, whose own practice and writing was very much on the borderland of public and private international law, and of course under the influence of Lawrence Collins himself. I've tried to continue that in my own writing, in foreign relations law, in investment law, a field that won't be a primary focus this evening, though I will provide some examples of my more general themes, on the principle of systemic integration, and in the general course that I gave at the Hague Academy last year. But in scholarship, the division between public and private international law remains profound, and the consideration of the interface between these two great systems governing the operation of law in the international sphere beyond the state remains comparatively neglected. So in choosing to return this evening to the general theme of the relationship between public and private international law, I can't cover the whole ground covered in my Hague lectures. You'd need to buy the book for that. Did I mention the book? Instead, I want to take just a slice of that much larger terrain for research that I began opening up there. But for the reasons that I shall hope to explain and defend this evening, it is, I think, the most consequential slice. In exploring it, I propose to do 5 things. Firstly, to consider why it is that this interface is so comparatively neglected and the possible consequences of that neglect. Secondly, to defend how the interface may be better explained by considering the respective roles of the two legal persons, the state and the corporation, which may be said to characterize, respectively, public and private international law. Thirdly, to answer the more radical proposition that the operation of the law beyond the state, public and private, may all be mashed up into a more general category of transnational law. Fourthly, to demonstrate how a focus on law as a means of securing legal responsibility for the delicts of those persons that are themselves creatures of the law, namely states and corporations, actually operates to delineate the respective function of public and private international law. And fifthly and finally, to suggest that developments in the field of international dispute resolution support the development of a body of general principles governing that process across the public-private divide. Part 1, a neglected relationship. It remains a striking fact that the two legal disciplines that aim most completely to provide for the operation of law beyond the state have apparently little to do with each other. That division was hardwired into what might be called the Victorian acquis, the collected ideas of the Victorian era, elements of which are still very much with us. Oppenheim, in his first edition, 1905, maintained that the subjects of rights and duties under international law, and here he's referring to public international law, were states solely and exclusively. It was a law for international conduct of states and not of their citizens. Rights which might necessarily have to be granted to individuals were not international rights, but only rights in municipal law. Private international law, he said, which concerned such matters as fall under the same time under the jurisdiction of 2 or more states, was not a part of international law. Well, the feeling was mutual. Dicey, in his first edition, 1896, rejected the name private international law for the subject of his great treatise, The Conflict of Laws, as inaccurate and misleading. It confounds 2 classes of rules, he said, which are generically different from each other. The principles of international law, properly so called, are truly international because they prevail between or among nations, but they're not in the proper sense of the term laws, for they're not commands proceeding from any sovereign. By contrast, he thought private international law was real law, because it did proceed from the commands of a sovereign of a given state, but wasn't really international because it was only concerned with the determination of private rights. The paradigm subject of Dicey's treatise was the private individual, and he regarded the corporation as a fiction of the law which was artificial, whose rights and duties were to be determined only by analogy. This division, nevertheless, had an important consequence, I think, for private international law's self-perceived separation from the public realm of politics and state interests. As Professor Horatio Muir-Watt puts it, the new perspective prevailing within the discipline, now conceived as distinct from public international ordering of interstate relationships, was that a coordinated legal realm beyond the reach of state politics, under the aegis of the private, was sheltered at the same time from both parochial struggles in domestic public law and from the colonial appetites that found support in its public international counterpart. Well, of course, the division isn't just one of subjects, but also of the function of law and the methods by which this is to be achieved. Neil Walker puts it that public international law is essentially always concerned, however defined and envisioned, with a series of convergent approaches that seek some kind of common normative scheme, whereas, of course, private international law is determinedly pluralist. It sees the world as a diverse set of overlapping and interdependent legal regimes, and the function of private international rules is to act as a kind of Harry Potter sorting hat, a switching device between those systems. Well, how then might we explain, given this wide divergency, the interface? There has been some very valuable contemporary scholarship on the relationship, one of whose exponents is sitting before me this evening, Professor Mills, much of which has been focused on the influence of charting the influence of public international law as a source of private international law, shining a light on the fact that it owes its origin as a subject to that same emergence of the separate sovereign states in early modern Europe, and the attempts through the codification process to re-achieve some unity in its rules. Well, those issues are very important, but they're not the consideration of my focus this evening, because it seems to me that they don't quite get at some more serious shortcomings of the public-private divide in international law. They don't interrogate the purpose behind the public-private divide and the points at which it intersects. One consequence of this divide is that it operates to separate the law that's concerned with the exercise of political power and the policy choices that we make for public purposes from the exercise of economic power by private actors, notably corporations regulated largely by private international law. Well, to each of these exercises of power, we give the labels respectively of sovereignty and property. Yet, as Kostyaniemi has shown, this separation is artificial. Sovereignty and property form a typical pair, he says, of legal opposites that, while apparently mutually exclusive and mutually delimiting, also completely depend on each other. We're ruled by sovereignty and by property, but at different moments with different emphases. And then he says, I think very wisely, for most people, sovereignty's power, especially its international power, seems obvious, while the power of property has become invisible. No doubt its invisibility is in part due to the ideological thesis that only sovereignty is real political power, while property only describes something that's naturally due to us, apolitical and unproblematic. But I think it's a mistake to think that the structures of private international law that enable the exercise of transnational economic power in a purely technocratic way, as if the only questions were ones of economic efficiency, where the law's task is only to facilitate but not to control, insulated from those public political choices. Only a consideration of the impact of law on both sides of the divide, and in particular the interaction between the two, could, I think, produce a more accurate account of the manner in which international law facilitates and constrains the real exercise of power in the world. So for this purpose, I think we need to go back and have a closer look at those two legal persons, the state and the corporation, that I introduced at the outset. Part 2, States and Corporations. It's a striking fact, isn't it, that the primary holders of rights and obligations arising from sovereignty and property in each of public international and private international law actually aren't natural persons, but they're legal or juristic persons, the state and the corporation. Now, of course, they're both creations of us, of human beings. Real people lie behind each. The state can't act without government ministers, officials, members of parliament, judges. A company can't act without directors and officers. And of course, natural persons can and do hold property and incur rights and duties. But the engines of economic power in the world, small and large, the means by which such power is held and exercised, are nevertheless corporations. The significant point for present purposes, as David Runciman has recently reminded us, is that we've developed two artificial creatures of the law which enable us to engage in the collective enterprises of government and commerce, respectively. Now, of course, as a matter of political philosophy, this insight isn't at all new. It was Hobbes in Leviathan who compared the Commonwealth or state with the private corporation as both being bodies politique, artificial persons with separate personality from those natural persons who'd created them. But what I maintain here is that examining the operation of public and private international law in this light illuminates the interface between them, since it's these artificial legal persons that have emerged as the principal holders of power on the international plane, the legality of whose actions is a function of public and private international law, respectively. And they've got two common characteristics. The first of those characteristics is durability. They have the potential, at least, to be durable. Unlike you or I, they're not mortal. They may therefore outlive the normal span of human life. And that quality has some real benefits because it facilitates long-term planning. In the case of states, this is particularly important since it means that agreements between states, treaties, aren't merely personal compacts that expire with the rulers that made them, but enduring engagements on behalf of the community as a whole. Here's Marriott, the King's Advocate, putting the point in 1764. The sovereign contracts not for himself as a private person, but as a public one. In other words, he binds himself, his successors, and his people as the great representatives of a whole kingdom who neither dies nor changes in his national capacity. James Crawford underscores the contemporary importance of this point, saying it's not too much to define state as the principal mechanism for the transmission of the accrued rights of human communities over time. This is true not only of their boundaries and jurisdiction, but also of their obligations. Governments and governmental arrangements change, leaders come and go, constitutions are overthrown, but unless otherwise agreed or decided, the state continues. In a world in which long-term planning is important, we might argue that imposing obligations on states contributes to a sense of ongoing security and predictability, which is valuable to any corresponding rights holders, and which would be lost if obligations were allotted only to officials or leaders. Corporations, too, have been described as sempiternal. They can outlive natural persons and thereby become an intergenerational vehicle for the transmission of resources, the pursuit of long-term commercial projects, and the engagement of concomitant long-term liability. This doesn't, of course, mean that either of them are necessarily eternal. States, as Natasha Wheatley has reminded us in her remarkable recent study of the end of the Austro-Hungarian Empire, can die just as much as new states come into being, and so, of course, can corporations die through insolvency or dissolution. The second quality which these two legal persons share is that they are replicable. It's indeed fundamental to contemporary public international law that the state, whatever differences it may have in real economic or political power, is treated in law as the same as any other state, and that new states can, provided the conditions of international law are met, be created, and when they do, share the same attributes of statehood. So, too, it is with corporations. The reforms of company law in the 19th century served to turn the corporation from something exceptional, which, like the East India Company, had existed only by special charter, into a ubiquitous legal institution that anyone who met the law's requirements could access and utilize. Well, significant though these similarities are, nevertheless the state and the corporation are, of course, very different legal persons, differing relevantly here in terms of applicable law and function. In terms of applicable law, the state is, of course, governed in its international relations by public international law, whereas the corporation is, by contrast, always a creature of national law, its ability to operate internationally being facilitated by private international law. Moreover, the functions of each as a collective enterprise are very different. The state existing to fulfill public functions, the corporation as a means of facilitating commercial enterprise and investment. But these distinctions are the result of political choices over time. Earlier generations saw no inconsistency in allowing companies to operate as company states, exercising what we would now regard as exclusively East India functions, exclusively state functions. That, of course, was sanctioned by the Lord Chief Justice in the great case of the monopolies in 1685, in the case of the East India Company, and it took the experience of the anarchy that this could cause, exposed by Burke in his speech on the impeachment of Warren Hastings, to bring about the separation of the corporation from the state in international affairs. Well, of course, this is something we may be about to learn again across the Atlantic. Plainly, Congress and the US Supreme Court are alive to the issue as regards the relation between foreign states and their corporations, as recently confirmed in the TikTok and Garland decision of the 17th of January. We'll have to see whether the same considerations are applied to the relation between the executive and corporate power in the United States domestically. The unchaining of the corporation as a free actor in the private international law sphere is also the product of essentially political decisions in the development of neoliberal economics in the service of globalization. The wide recognition of foreign corporations, which has been long accepted in our law, was not widely accepted internationally even as late as the 1960s. the free movement of capital and currency, and the broad acceptance of party autonomy and choice of law and jurisdiction in international commercial contracting are two the products of particular decisions of our time. Well, while the experience of the East India Company reminds us of the vice of clothing private corporations with public power, by contrast, the state, as a public corporation with plenary personality, retains a dual public and private character. It retains that capacity to act in a private commercial way as well, and it may, for that purpose, establish state-owned enterprises which themselves exercise elements of both governmental and private functions, operating on that interface between public and private international law. Well, I'm not suggesting that a focus on these two legal persons offers a complete explanation of the preoccupations of these two great subjects. On the contrary, of course, public international law was reshaped in the late 20th century by a focus on the rights and duties of the individual as a subject and not merely as an object of international law. And private international law fulfills vitally important functions, ensuring that individuals can secure recognition of their status and transactions across national borders, as confirmed by the International Court of Justice in its Namibia opinion. But what I do argue here is that a specific focus on the activities of the state and the corporation may expose to view more clearly the function of the law beyond the state in the control of the exercise of power where it gives rise to a breach of the rights of others. More generally, I suppose, the widespread activities of both states and corporations in cross-border commerce prompts reflection on whether the old categories of public and private international law are any longer a sufficient explanation of the operation of law beyond the state, or whether they're now subsumed into a broad umbrella field of transnational law, a question to which we must now turn in part 3. It's 70 years since Dean Jessup issued his provocative claim for a transnational law that includes all law which regulates actions or events that transcend national frontiers. He insisted that such an approach must include, but not be completely described by both public and private international law, and must include corporations as much as states and individuals. Jessup's lectures seem to have retained considerable contemporary power. Indeed, they've spawned a whole transnational law movement. But there's some real reasons to be careful, I think, about an uncritical adoption of Jessup's call for a brave new world in which everything, public and private, can be housed under a new compendious umbrella. After all, both the municipal law of states applied under private international law rules and public international law gain their legitimacy because they're products of a political community whose rules meet the general requirements of publicness. They're known in advance. They're rules of general application. They apply equally to all persons and thus command the consent of those to whom they apply. We should be wary of rushing to substitute such rules for an appeal to a transnational law that may be potentially dangerous precisely because it undermines the very public qualities that we seek in law and the consent of the community which law aims to serve. The contemporary appeal of transnational law has been driven by the observation that there are many forms of private ordering that are created largely by private actors through contractual and corporate structures that are facilitated by a broad party autonomy in private international law and seem to operate largely outside the purview of state control. Such claims are regularly made for the development of international commercial arbitration as a system of private dispute resolution, triggered by an exercise of party autonomy alone and capable of operating in its own realm, delocalized, and so it's claimed, in the words of the late Emmanuel Gaillard, as an autonomous legal order. Well, there's significant evidence that, at least in procedural terms, much international arbitration does take place outside state control and is shaped by private decisions, both by the parties and by the private institutions that administer such arbitrations. But I think that international commercial arbitration can only sustain a claim to semi-autonomy. The whole system's premised both on public and private international law. It depends upon the continued support of states for the enforcement of awards under public international law through the medium of the New York Convention. It also relies on the core techniques of private international law applied in the distinctive context of arbitration to choose the law applicable to both the expression of party autonomy, namely the arbitration agreement, and the law applicable to the substance. One need look no further than the recent decisions of the Supreme Court of this country in Enker and Chubb and Unicredit and Ruschem to see the significance of the choice of law process. In both of those cases, the determination of the law applicable to the arbitration agreement produced real-world consequences for the efficacy of the arbitration process. The experience in international arbitration provides a more general answer to those who assert a wider claim to the existence of transnational law beyond the state. Because the ultimate question is always what endows such norm production with the binding quality of law. Take the case of cryptocurrencies. The explicit claim that is made by the architects of crypto is that it's possible to take a key public function of states, namely the issue and control of money, and replace it with a private form, which exists in cyberspace, outside the state, beyond its control, entirely at the behest of private actors. Well, it's true that cryptocurrencies may well pose very challenging new problems for us in the law, but they're still, after all, property interests that were created by human beings. To the extent that disputes arise, those disputes fall to be resolved not in cyberspace or in any other extraterritorial realm, but before very terrestrial tribunals. Nowhere is this better illustrated than the current litigation pending before the English courts by the person who claims to be the inventor of Bitcoin, Dr. Craig Wright, who, disappointed by what he claims was the theft of the keys that he needs to unlock his holdings, has sought relief not in cyberspace, but before the English High Court. I don't doubt the existence in the world of commerce of a highly developed systems of private ordering, but to treat these as distinct forms of law in their own right in the transnational sphere is to miss the essential point of law, which is not just to facilitate and legitimate the exercise of power, but also to control it. A thoroughly deformalized view of transnational law that equates formal and informal mechanisms fails in that fundamental endeavor. We can't, in this regard, I think, treat the exercise of economic power as any less political in its effects on human society. To hand the keys of such power to the corporation to determine its own rules is to ignore the basic function of law in the international sphere. And for that, we need the engagement of states as well as private parties. So let me turn then in part 4 to the complementary roles of private and public international law in securing the legal responsibility of the corporation and the state for their respective activities. Part 4, legal responsibility outside the state. So here I shall take first the position of the corporation when it acts outside the borders of the state of incorporation, and in the second section, the position of the state. Well, in public international law, the debate on the responsibilities of corporations has been principally carried on in the language of social responsibility and within a human rights context, framed by the principles prepared by John Ruggie as Special Representative to the Human Rights Council on Business and Human Rights in 2008. I'm not suggesting that these principles lack all value. It may be possible in some circumstances to recognize that corporations owe particular duties in human rights, particularly in cases of complicity, as we discussed in Urbasa in Argentina in relation to the human right to water, or more radically as a majority of the Supreme Court of Canada considered in the context of slave labour and the Nevson litigation. But so far, at least, the very considerable intellectual effort devoted to constructing a new public international law of human rights remedies against corporations has borne only modest fruit. Much of this work leaves out of account the more basic point that national systems of private law already have developed a set of remedies for cases in which private actors, whether individuals or corporations, cause harm to others. That's what the law of tort is there for. When such duties are transposed onto the international level, they give rise to a whole set of complex private international law issues of jurisdiction, applicable law, remedy, enforcement. And at all of those stages, it's private international law that has to supply the answer. It's not the case that private international law actually has all the answers. I'm not seeking to minimize the difficulties, but to consider the legal duties of corporations to answer for harms that they cause internationally without thinking about private international law is to leave out of account, I think, the most important arena in which such duties may be pursued. The corporation is, after all, itself a creature of private law, So its recognition in cross-border context falls to be determined in the first instance under private international law. And on that point, public international law agrees as well. That's what the International Court of Justice said in Barcelona Traction when it held, whenever legal issues arise concerning the rights of states with regard to the treatment of companies and shareholders, as to which rights international law has not established its own rules, it has to refer to the relevant rules of municipal law, a point reiterated as recently as 2019 in the certain Iranian assets decision of the same court. Focusing on the application of the rules of private international law to the responsibilities of corporations for their international conduct yields a very different picture on the crucial question of the extent of the jurisdiction over the state over such conduct. In public international law, debates about the doctrine of jurisdiction tend to focus on the exercise of the public regulatory power exercised by executive and legislative organs of the state and, significantly, its limits. But in private international law, while the question is still ultimately a question of regulatory power, it's principally concerned with the judicial organs of the state in their exercise of jurisdiction for private law claims. Here, a much more expansive picture emerges as courts have responded to the global activities of multinational corporations by developing the private international law of tort and of remedies. Time permits me only to sketch three of the most important elements of these developments in the private international law of this country. 1. Extended personal jurisdiction. First, the court isn't limited to acts within the territorial jurisdiction of the state, nor to acts by a national of the home state. Private international law permits the institution of civil proceedings over a much broader range of conduct, provided that the forum remains the appropriate place in which to try the action, because there's a substantial connection between the wrongdoing and this jurisdiction. This point's got special salience in claims for tortious liability against corporations in view of the Supreme Court's expansive reading of the requirements of the tort gateway in Brownlee and FS Cairo in 2021. Second example, worldwide interim relief, particularly in personam freezing injunctions. We can see that as a reaction to the increased mobility of assets and interchangeability of international companies, and I'm quoting there from one of the early cases. In these circumstances, the grant of provisional orders, limited in scope to the territorial jurisdiction of the court, will be an inadequate response. A key recurrent feature in these cases has been the evidence of the defendant's misuse of the separate legal personality of the corporation to evade enforcement. But the court won't allow a defendant to use a sophisticated and intricate network of interrelated English and foreign companies as a mechanism, as another judgment put it, the silken skein of his spider's web, through which the defendant can dispose of his assets. It will distinguish between genuine third-party interests and cases in which, because of the defendant's substantial or effective control, it will pierce the corporate veil. Now, that development, largely in England a judge-made revolution, has reshaped the face of transnational litigation. It demonstrates the capacity of private international law to innovate in ways that respond to the new realities of the global conduct of business through corporate entities. The third and perhaps most significant development can be seen in the pursuit of claims against the parent companies of multinational groups, alleging tortious failure to supervise the conduct of their subsidiaries abroad. Well, late 20th century experience with such claims was that the operation of the ordinary rules of separate corporate personality, when applied in the context of private international law, tended to insulate the parent company and its assets. Applying the doctrine of forum non-convenience, it would ordinarily be the foreign court and not the court of the home state that was the appropriate forum, witness the Bhopal litigation in the United States. If instead the plaintiffs brought suit in the place of tort and joined the parent company, it would be held that the resulting judgment was unenforceable against the parent in its home country, as we know from the decision of the Court of Appeal here in Adams and Cape Industries. But more recent experience in this country, starting at the turn of the millennium, in the context initially of industrial accident claims, but continuing in environmental and human rights actions, has begun to indicate a different route. These claims don't disturb the basic elements of separate corporate personality or the general rules of jurisdiction. They just pursue a direct claim against the parent company, alleging that it, and not just the operating subsidiary abroad, owes a duty of care to the claimants in tort. The Supreme Court upheld this approach as tenable in Lungau and Vedanta Resources in 2019, a case in which the claimants, all Zambian citizens and residents, brought claims against the defendants, a British parent company, and its Zambian subsidiary, alleging damage arising from pollution caused by discharges from a Zambian copper mine. The Supreme Court, reversing the lower courts, held that the claim as pleaded did disclose a triable issue against the parent. The liability of a parent company in negligence in relation to the activities of its subsidiaries wasn't a distinct category of liability, there being, quotes, no limit to the models of management and control which may be put in place within a multinational group of companies. The court held that everything depends on the extent to which and the way in which the parent availed itself of the opportunity to take over, intervene, and control, supervise, or advise the management of the relevant operations. And of course, that beachhead established in Vedanta has now been followed by other similar class actions currently pending before the courts. So while separate corporate personality established under the law of the domicile confers some very significant benefits for the conduct of multinational business, it also carries with it potential liability. Well, I don't want to suggest that these developments in private international law in some way place private international law in a place apart from any application of the general doctrine of jurisdiction. On the contrary, as Lawrence Collins has shown in both his academic writing and in his judicial decisions, the frequent references in English judgments to considerations of comity denote a judicial shorthand for the outer boundaries imposed by public international law. And we find these in the fundamental principles which were articulated in the Friendly Relations Declaration of 1970, the duty not to intervene in matters within the domestic jurisdiction of any state, and the principle of sovereign equality. Such principles were recently applied by reference to the writings of F.A. Mann by the Supreme Court in Kariva and Bedzamov. Where there is a genuine conflict of jurisdictions, we have to balance the sovereign ability of one state to exert its powers against the claims of other states in respect of their domestic jurisdiction. One cannot do that simply on the basis of a narrow notion of territoriality. It has to be determined by sufficiency of connection. In order to do that, there must be a counterbalancing consideration of the legitimate sphere of jurisdiction of other states. But at the same time, the developments in judicial jurisdiction which I've referred to show that provided those outer parameters are not infringed, private international law has proved to be a site of considerable innovation in securing the legal responsibility of the corporation for its international conduct where it causes actionable damage to others. Well, what about the state? If we turn our gaze to the liability of the state for its activities abroad, experience, particularly in the context of human rights claims, confirms that this question too isn't determined by a territorial conception of jurisdiction in international law, but rather is determined as part of the law of state responsibility. Much confusion was caused by the early decision of the European Court of Human Rights in Bankovic in 2001, which had limited the sphere of operation of the Convention to the territorial jurisdiction of the member states. But underlying that jurisprudence was a confusion of thought about whether the word jurisdiction in the Convention means the public international law doctrine of jurisdiction, as the court maintained, or simply the exercise of power or control by the state. When used in the human rights context, jurisdiction plainly denotes this latter meaning, the fact of the exercise of state power, rather than the legal constraints on its exercise. The attempt to apply the doctrine of jurisdiction in such cases not only subverted the fundamental purpose of human rights, which after all is to protect the citizen against abuses of power by the state, it also turned the doctrine of jurisdiction itself on its head, the purpose of the doctrine being to constrain the exercise of state power externally. Yet what these cases did was purported to apply the doctrine in order to license just such excesses. An important element in that fallacious approach was to tie jurisdiction to territory. In the context of human rights, this was seen as requiring an all-or-nothing approach. Either the state had effective control over the particular territory and therefore had to guarantee all of the rights, or it had no such control, in which event the law of human rights had nothing to say. Human rights couldn't be divided or tailored. Well, the European Court eventually rejected that doctrine and embraced an approach that more closely reflects the international responsibility of states in the Alskany decision, a case that was in which the UK Supreme Court took a like approach in the case of detention in non-international armed conflicts in Afghanistan, in Al-Wahid and the Ministry of Defence in 2017. So how then does public international law deal with the mixed public-private capacity of the state embodied in the state-owned corporation? This can be traced through its approach to attribution for the purpose of state responsibility, through the concept of the public body in trade law, through state immunity, and enforcement of state debts against the assets of a state-owned corporation. Let me just telegraph a few points on each. So, of course, it's axiomatic that the law of state responsibility requires not only the commission of an internationally wrongful act, but also that that conduct be attributable to the state under international law. And for this purpose, the distinction between public and private conduct takes on a particular significance in the context of a state-owned corporation. Such corporations can engage the responsibility of the state, but only if and to the extent that they're empowered to exercise elements of governmental authority, or where they're in fact acting on the instructions of the state, or where their acts are subsequently acknowledged and adopted by the state. For example, in the case in which I sat in a case called Ampal American in Egypt, the tribunal was confronted with evidence that the specific acts of the corporation, which were the subject matter of the complaint, had been actually directed by government officials. Article 8 of the state responsibility articles was therefore engaged, even though the state had organized its affairs through separate entities. This question of how to categorize the acts of state-owned corporations has taken on particular heightened political significance in the context of the dispute between the United States and China under the aegis of the WTO in the China anti-dumping litigation in 2011. Because the United States said that any state-owned corporation in China was a public body. The only question was whether it was owned by the state. The appellate body, much to the chagrin of the United States, demurred, reversing prior decisions, disagreeing on the basis that the same test applied in the law of state responsibility should also be applied to the determination of a public body. The question was whether or not the body in the relevant case was exercising a governmental function rather than a private or commercial one. And of course, that question is also hardwired, isn't it, into the law of state immunity. And it's quite explicitly linked to the relationship between public and private international law in the text of Article 10 of the UN Immunities Convention, which describes the commercial exception as a state engaging in a commercial transaction with a foreign national or juridical person, which, by virtue of the applicable rules of private international law, fall within the jurisdiction of a court of another state. Once it's determined that a plea of immunity won't avail, the consequence, of course, is that the claim against the state falls to be determined according to the ordinary rules of private international law, which also has important consequences for the applicable law. Now, of course, working out what is a commercial transaction is something on which reasonable minds may differ. This much has been plain from the very first decision of the House of Lords and Premier Congreso through to its more recent decisions in NML Capital in Argentina and Argentum and South Africa. But the significance of the determination as a fork in the road between a claim proscribed by public international law and a claim impleading a foreign state that's governed by the ordinary principles of private international law is plain. So also it is in the determination of the relation between the state-owned corporation and the state in the context of the enforcement of arbitral awards, as was confirmed in the case of Gécamines and FG Hemisphere, where again the Privy Council referred to the rules of state responsibility in order to make a distinction between the ordinary case where the state-owned corporation would be regarded as a separate entity and those more limited cases where it was plainly exercising elements of governmental authority, an approach further endorsed in the context of public international law by the International Court in certain Iranian assets. Well, what's the significance of all of this detail that I'm throwing at you on the law of state responsibility for this purpose? what I maintain is that in these cases we see courts on both sides of the divide, as it were, navigating a terrain, determining the respective responsibilities of the state and the corporation, and that hybrid, the state-owned corporation, and applying the public-private distinction proves to be highly consequential. But in the determination of that question, whether by a national court or an international court or tribunal, the court is making a choice of law, adopting a private international law rule to determine the existence and liabilities of a corporation, and a rule of public international law to determine the responsibilities and immunities of a state. I conclude in part 5 by focusing on the adjudicatory process itself, by which all of the disputes that we've been considering here are resolved. Because in all of this, it's the process of international dispute resolution itself that sits on the interface between public and private international law. To what extent, then, can international dispute resolution by national courts and by international tribunals be envisaged as part of a common enterprise? Concluding their book on the settlement of disputes in international law in 1999, late John Collier and Vaughan Lowe, very much still with us, both then of this university, wrote, "There are certain stages and problems common to all judicial procedures for the settlement of international disputes. The similarities are more pervasive as the frequency with which international courts and tribunals of all kinds refer to each other's jurisprudence indicates. There are clear signs," they said, "of a body of international procedural law emerging." Well, I agree. How could I not? But it's necessary to be clear about the nature of the claim. National courts, international arbitral tribunals, and international courts are very different animals in terms of their institutional character. National courts are the judicial organ of a particular state. Their powers are determined by their constitutional position within that country. At the other end of the spectrum, a standing international court, such as the International Court of Justice, is a judicial organ of the United Nations. International arbitral tribunals sit somewhere semi-autonomously in the middle. In international cases, all of this necessarily produces very different consequences in terms of jurisdictional scope, the jurisdictional scope of the tribunal, the law applicable, and the detail of the procedure. Well, so much so obvious. But my claim here is that there is a convergence at the level of general principles of procedural law. And delivering another inaugural lecture in Geneva in 2008, the late James Crawford emphasized the theme of continuity in international dispute settlement, both historical continuity and continuity in the process of dispute settlement, public and private. This, of course, has been the whole philosophy behind the new course that, together with Dr. Faden Verasis, I'm developing and delivering on the master's program here. The very act of considering side by side the private and the public international law solutions on the key procedural stages of a dispute has brought such general principles into sharp focus. Since across the fields of public and private international adjudication, one finds the same consistent reference to fundamental rules of procedure. In public international law, this is the very language of the International Law Commission's Model Rules on Arbitral Procedure, which were taken in to the Exit Convention on the Settlement of Investment Disputes in 1965 as one of the limited list of grounds for the review of an investment arbitration award. In a case called Frapport in the Philippines, on which I had the honor of sitting under the chairmanship of Judge Tomker of the International Court, we held that this expression is intended to denote procedural rules which may properly be said to be general principles of law in the sense of Article 38(1)(c) of the Statute of the International Court. The right to be heard was one such principle. And in 2019, the Institut du Droit International agreed, resolving that the principle of the equality of the parties is a fundamental element of the rule of law that ensures a fair system of adjudication, and as such is a general principle of law applicable to the procedure of international courts and tribunals. Well, in international commercial arbitration, the tribunal's procedural flexibility finds its limits in the proviso to Article 17(1) of the UNCITRAL rules, which requires that the parties are treated with equality and that at an appropriate stage, each party is given a reasonable opportunity of presenting its case, a provision which has been described as the procedural Magna Carta of international commercial arbitration. The same point was recently emphasized by Lord Leggett delivering with Lord Hamlin the judgment of the Privy Council in Gol Linus and Matlin Patterson in 2022, when he explained that though the law of the enforcing court was the law applicable to a challenge to the enforcement of an arbitral award on due process grounds, quotes, "It by no means follows, however, that the question is to be answered by applying local standards of what constitutes a fair procedure. It does mean that the court should be seeking to identify and apply basic minimum standards which would generally, even if not universally, be regarded throughout the international legal order as essential to a fair hearing. In the enforcement of foreign judgments in private international law, at least since Lord Ellenborough's judgment in Buchanan and Rucker in 1807, it's been plain that it's contrary to the first principles of reason and justice to enforce a foreign judgment at common law where the right to be heard has not been respected. The same fundamental principles of fairness finds contemporary reflection in the two Hague Conventions, which now dominate the English reception of foreign judgments. It's not that the answers to the procedural problems arising in international disputes are identical, but it is that the problems are shared ones and that close comparative research indicates that there are more common solutions to be found than is often supposed. Approaching international dispute resolution as a field has got important implications for both teaching and research. This is the world that our students will come into should they choose commercial practice, contentious practice rather. It will demand of them methods of thought and analysis that are both comparative and international. The process of international dispute resolution also has a larger significance as a field of research because it's intrinsically linked to what the proper administration of justice requires in the context of international disputes. It provides an important insight into what it really means to speak of general principles of law common to the international community, something which is taxing the International Law Commission at present. The task of examining those principles that can properly said to be general and thus applicable in international disputes decided under both public and private international law seems to me to open a new and fertile seam of research which is part of a broader comparative examination of the process of international dispute resolution, may, I fear, ultimately find expression in a new book. Let me conclude. Public and private international law constitute two complementary systems of law governing conduct beyond the state. So far from being separate spheres, they're two parts of a whole, each reliant on the other. The state and the corporation, which embody respectively sovereignty and property, are both constructs of the law. The function of law is not merely to empower and clothe these artificial persons with legal authority, it's also to impose legal responsibility where the exercise of power gives rise to a breach and causes injury to others. Only by placing these two great systems side by side can we see clearly where that responsibility lies and the necessary development of the law. Though I've focused my remarks this evening on the state and the corporation, it's important to recall that these entities are the product of human creation. They're for us. We live in challenging times in which the power of both states and corporations in the international sphere seems once again unleashed, unrestrained by law. But as F.A. Mann wrote some 50 years ago, the scholar, as well as the practitioner, particularly the municipal judge, must not allow his temporary disillusionment to overshadow the ultimate unity of the law. Thank you very much.